Welcome to Advocating for Dads with Jana Jones.
Hey everyone, welcome into an all-new episode of Advocating for Dads with Jana Jones. I am your host, Mike Leon. Jana here is a North Carolina family law attorney. She's based out in Charlotte. She's been helping fathers understand their rights and stay involved in their children's lives. And in today's episode, we're talking about what happens after the custody order is in place, when the other parent simply won't follow it. Jana's going to explain what enforcement really means, what evidence matters most, and how North Carolina courts respond when a parent ignores a court order. Jana, it's good to see you as always. Let me ask you, when a court order isn't being followed, what does the enforcement part of this actually entail and look like in the state of North Carolina?
Hi, Mike. Great to see you again. So enforcement kind of comes in two parts. One is, what do we do with this order when we're out in the real world? And the other is, how do we enforce it in the courtroom? So in the real world, the whole point of getting a custody order is so that everyone is able to know exactly what rights and responsibilities each parent has as it relates to custody, as it relates to legal custody, and as it relates to physical custody. And so specifically, we see more challenges in the real world around enforcement of physical custody, where one parent might withhold the child even though the child is supposed to be with the other parent. And so in that instance, what you have the ability to do when you have a court order is to reach out to law enforcement to try to effectuate that order. So for instance, if you are supposed to get your child on a particular weekend and the parent tells you that they're not going to let you, you are able to reach out to law enforcement to ask them if they will help you get your child back by either escorting your child to you or escorting you to go get your child.
What kind of violations, or what are some examples of violations that most often bring dads back to the court? I'm assuming something withheld communication-wise. Is it something else?
So a lot of times it's the physical custody. If you're in a situation where maybe you're getting every other weekend as it relates to your custody order, and on a particular weekend that was supposed to be yours, the other parent has plans for that child, and decides that it's going to be better to do what they plan to do than to have you have your court ordered visitation time. That's probably the number one complaint that I see as it relates to violation of physical custody in the order.
And we've talked about this on previous episodes, but in terms of documentation, before they even file anything, what would you advise a dad out there to document so that way they show the court that this order is being violated?
So the first thing that I always tell folks is your best evidence is your testimony. Does the court believe you? Are you credible? Because you're not going to have an exhibit for every single thing in your life, right? If you're talking about an agreement between parents that was verbal about when the exchanges was going to happen, and it has not been reduced to an actual order yet, you don't really have a way of proving that, because you're going to say one thing and he or she is going to say the other. And it's going to come down to, who does the court actually believe? So when you're starting out and you don't have an order in place and you're looking to get one, the first thing that I tell dads to figure out is, what kind of schedule do you want? I always start with, if you could write the order, what would that order look like? Because that's different for every parent and for every father. Some fathers are looking for joint custody. They've got the lifestyle and the schedule that allows that to happen, and that's what they want. Some fathers want primary custody. They feel like mom's not doing what she needs to do, and that the children would be better off with him on a more permanent or full-time basis. And then some fathers are looking for kind of the standard visitation schedule of every other weekend, because their lifestyles don't allow for them to do anything more than that. And none of those are wrong. It just comes down to what's right for you and knowing how to communicate that to your attorney so that they can advocate for you appropriately.
John, I want to talk about contempt over these next couple questions. When it's time to file a motion for contempt, in your experience, what do the judges out in Mecklenburg County, what do they typically see in those type of cases?
So the first thing you have to know about contempt is that there has to be a specific provision within the order that the other party has violated. So you might want to hold your ex in contempt because they're just making co-parenting extremely difficult, but that is not going to be a provision in the order. Be nice with each other and do good co-parenting. That's not something you can hold somebody in contempt for. What you're going to be looking for is, what's in my order specifically as it relates to physical and legal custody that I'm saying that the other parent violated and that the court has the ability to see and to know. So for instance, a lot of times we have language in orders talking about no degradation or speaking ill of the other parent to the child, right? But it's going to be very difficult to enforce that provision because the person who's hearing these things about you is the child. And generally speaking, you're not going to have the child testify for a number of reasons. And if the child can't testify, then trying to tell the court what your child told you that mom or dad said about them is going to be hearsay, and the court's not going to be able to hear it.
So let me ask you now, if a parent is found in contempt of the court, what kind of consequences follow from there?
Sure. So it can be a number of things. It could be an awarding of attorney's fees. It could be jail time, whether that's suspended sentence or an active sentence. The court could order makeup time in a situation, for instance, where one parent has withheld the child and the other parent wasn't able to get their court order visitation time. They can say you've got to make that time up. So maybe 3 or 4 every other weekends were missed. And so we're just going to do a 10-day or a 15-day solid with the other parent. The judge has, kind of carte blanche in how they want to punish the other parent if they are found in contempt.
Jana, what about if this order itself is, let's say, vague in nature? Like, does it make sense at all for parents out there to ask the court for clarification, modification? Like, what would you recommend?
So to modify an order once it's in place is a two-pronged test. You have to have a substantial change in circumstances since the entry of the prior order, and then the court has to do a best interest determination. So my advice in that scenario, as far as vague orders, is don't get a vague order. You want your order to be as detailed as it can be. Can you think of every and any instance that could come up? No, you can't. But you want to be as succinct as you can and as comprehensive as you can and as clear as you can in your order, because where there is ambiguity, you have a hard time enforcing it. Ambiguity makes it difficult for law enforcement to enforce it, and it makes it difficult for the court to punish the other parent if they violate something. So my biggest piece of advice is make sure your order is not vague. That order being vague in and of itself is not going to be a basis for modification.
And in your experience, how do the courts view repeated small violations compared to, let's say, one more serious act of defiance?
I wouldn't say there is a scale. A violation is a violation. If you are trying to hold the other parent in contempt, my thought is for each and every violation, you want to put all of that in your motion for contempt. Otherwise, you're coming back to court multiple times. So if there has been something related to the physical schedule that has been violated. And let's say, for instance, one of the parents was supposed to turn over, a social security card or a passport or something to the other parent, and they didn't do that either. Then you put both of those in your motion for contempt and ask the court to punish them for both actions.
And while that motion is pending, let's say, is there anything a dad can do for, let's say, some short-term relief if the other parent, especially, is withholding the child from them?
Again, law enforcement can, get involved and help effectuate that order, and that's something that can happen in real time. I will say that, my clients have had historically mixed results with trying to get law enforcement involved. A lot of times they don't want to do it. And so I just say you keep calling till you find someone who will listen to you, someone who will sympathize with your situation and help you out. But that is the power of having that court order, that law enforcement can help effectuate the order.
And as we wrap here, Jana, for the dads out there who've had to enforce orders maybe once, twice already, what wording or structure would you recommend that they include in these future custody agreements? So that way it makes the compliance clear and easy.
Yeah, so just make sure that there's no ambiguity. When it comes to the physical custody schedule, be very clear on who gets the child or children, at what points, what the exchange location is, what time those exchanges are supposed to happen, and things of that nature. And any good order is also going to have some language that if the parties want to modify something temporarily, say, for Thanksgiving, you're supposed to be exchanging at noon, but this year, because of a flight coming in, you're saying 2:00, that you put that in writing so that the other parent doesn't have ammunition to come back and say, hey, you violated the order. You said you were supposed to be here at 12:00 and you came at 2. Obviously these types of things happen. So you want to make sure that if you're modifying it in any kind of way to protect yourself from a potential contempt, that you do have it in writing. And my recommendation, if you're going to put it in writing, is to do an email, not a text message, because depending on what your text messages look like, and if you're able to download them properly, it can be difficult for you to enter them as exhibits into evidence.
Jana, thank you for the time, insights, analysis, as you always do. Appreciate it, as always.
Thanks so much.
And that wraps today's episode of Advocating for Dads with Jana Jones. Look, if you're a parent out there, you're facing another parent who refuses to follow a North Carolina custody order, do me a favor, visit lawofficeofjkj.com right now. You're going to schedule a consultation with Jana and the team and learn what enforcement options are available to you. Thank you, as always, for listening to this episode. But don't forget to like, subscribe, leave a review and comment, or share it with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.